National Library. This conference has been 3 years in planning. I think this is the longest event we've ever had to plan. Back in, I think, 2018, John Adams and Ryan Sherman reached out to me about hosting a conference here. So we originally scheduled this event for April of 2020. For obvious reasons, it did not happen in April of 2020, but we're really, really grateful that we were able to execute the conference on this particular date. And this date is actually a very meaningful one for the Federalist Society. 40 years ago today, the Federalist Society was founded with our inaugural student symposium at Yale Law School. So April 23rd. Is a great day, and I can't think of a better way to celebrate than being with so many friends from FedSoc. I know we're running a few minutes late, so I'm going to turn things over to Judge Readler in a moment. I want to offer a few thank yous. This has been a team effort to plan. John, Ryan, Joey Ashbrook, our president in Cincinnati, Mark Bremer in St. Louis, Eric Weston. So many people were really instrumental in planning this. I also want to make sure that I acknowledge Jana Bodor, who is a proud Midwesterner, as am I. So she has done so much work on this event. She's in the middle of a very busy stretch where we have 3 conferences in the month of April. So one more to go after this one, but thank you so much, Jana, and really appreciate all of your hard work. We've got a great schedule planned today, including some time at the end to tour the library if you have not seen that, actually the library and the museum. But I'm going to turn things over to Judge Chad Readler. Judge Readler is a longtime friend of FedSoc. He's a former chapter president in Columbus, a proud graduate of the University of Michigan. So I'm glad to have some more representatives from my home state. He's currently serves on the 6th Circuit in Columbus, Ohio, and I will turn things over to him to get started.
Thank you, Lisa. Welcome, everyone. It's great to see all of you here. Let me apologize for the informality of no tie. I made it to Springfield, but my luggage did not. And so if I get a call during the program, it might be United Airlines, and I might take it because I'm hoping that will arrive at some point later today. So it's a real pleasure to be here. I have been coming to the Midwest Conference. Thank you, yes. That's all we're going to take off. But
I'm not tenured yet.
Yes, we're on level playing fields. So it's really nice to be here because I remember coming to these meetings not 40 years ago. I don't think we had them then, but when we sort of met in a small conference room in a Chicago law firm. So to see all of you here in Springfield, having traveled, it's just really wonderful. And it's a great tribute to the Federalist Society and its impact on the legal movement and legal discussion in the United States. Before I start, I'm just going to acknowledge my friend Betsy Clark, who is here from, I think, Wisconsin, but originally Ohio. And I hope you'll take this in the right way, but you are a pioneer in my mind for the Columbus Lawyers Chapter of the Federalist Society. When I joined the chapter, you were already probably either president or past president at that point. So thank you for your longtime commitment to FedSoc. So unfortunately, my luggage was not the only thing that didn't make it to Springfield. Professor Sanders, who was going to join us on the panel, was sick yesterday and could not travel over. So, but the good news is we have 2 terrific speakers. I think we're going to have a really lively discussion, and I think you will all enjoy it. And certainly at the end of the program, I'll count on all of you to have some questions for our panelists. Our discussion today is appropriately about the 14th Amendment. That makes a lot of sense, being at the Lincoln Library. Obviously, the Civil War has fought over a number of things, including what ultimately become the amendments that followed as part of Reconstruction. And today's debate, I think, is going to be sort of narrowly on the privileges or immunities clause of the 14th Amendment. And we have 2 speakers who have sort of different views on that. I think you'll enjoy it quite a bit, and I'll introduce them in the order that they're speaking. First up is Professor Bernick. Professor Bernick joined the Northern Illinois University Law faculty in 2021. He teaches courses in constitutional law, criminal procedure, administrative law, and legislation. Before that, Professor Bernick was a visiting professor at the Georgetown University Law Center and the executive director of the Georgetown Center for the Constitution. And before that, he clerked for Judge Diane Sykes on the United States Court of Appeals for the 7th Circuit. His scholarship covers a range of topics from constitutional law to philosophy of law to social movements to law enforcement. His book, which I think you'll hear a little bit about today, The Original Meaning of the 14th Amendment, Its Letter and Spirit, with Professor Randy Barnett, was published by Harvard University Press under its Belknap imprint, quote, for books of long-lasting importance, superior in scholarship and physical production, chosen whether or not it might be profitable. But I hope it is. Professor Bernick received his law degree from the University of Chicago. Next up is Professor Wurman, and I think almost everyone here on the program has been invited because they live in the Midwest, except maybe for Professor Wurman, so that must be quite a compliment, that we were willing to get you all the way here from Arizona. Ilan Wurman is an associate professor at the Sandra Day O'Connor College of Law at Arizona State University. He teaches administrative law and constitutional law. He writes on administrative law, separation of powers, and constitutionalism. And his academic writing has appeared or is forthcoming in essentially every law journal or law review you've heard of. The Yale Law Journal, the Stanford Law Review, the University of Chicago Law Review, University of Pennsylvania, the Virginia Law Review, Duke Law Journal, and the Minnesota Law Review. All that's Michigan is the Michigan Law Review, but I hope that will be forthcoming. He's also an author of A Debt Against the Living, An Introduction to Originalism, and another book that I think you'll hear something about today. We have a copy of right here. We can promote it. The Second Founding, An Introduction to the 14th Amendment, which was published in 2020. Professor Wurman has also published a case book on administrative law. And since this is quite a knowledgeable audience, you'll know that he's a very frequent speaker at FedSoc programs around the country. So with that, Professor Bernick, do you want to start us off?
Absolutely. Make sure this is on. I think it is on. Of course, as a graduate of the University of Chicago Law School, I have never heard of the Yale Law Journal. Okay, so it's 9:46 on a Saturday, so I wouldn't blame you for being a little bit sleepy. But I think by the time we're done in about an hour or so, nobody's going to be asleep. I can't promise a reprise of the Lincoln-Douglas debates, but I can promise that at least one of us will suggest that the other holds a theory of the 14th Amendment that is less than Lincolnian. And I should add that I regard Lincolnian as a term of high approbation. Lincoln, for all his faults, was our greatest president, bar none. And I want to focus on one particular aspect of Lincoln's character and creed that distinguished him from his opponents: his rejection of Senator Stephen Douglas's raw majoritarianism. Lincoln believed as fervently as Douglas that people should be free to govern themselves, but he insisted that that freedom did not include the power to enslave others. Self-government was incompatible with subjugation and domination. There were certain fundamental rights that Lincoln, unlike Douglas, said couldn't be voted up or down. Now, I agree with Ilan about a lot. Our views of the Equal Protection Clause, for instance, are quite similar. Not so much the Due Process of Law Clause. And I emphatically agree with him that any plausible theory of the meaning of the Privileges or Immunities Clause needs to account for the fact that the clause was advertised as a means of securing the constitutionality of the Civil Rights Act of 1866, and the theories that hold that the clause just incorporates the Bill of Rights or all enumerated rights against the states can't do so. And yet, for all of that, Ilan and I see some things very differently, for both methodological and, I think, normative reasons. This disagreement's easiest to perceive in his discussions of the Privileges or Immunities Clause. Ilan is so focused on legal history that I think he neglects how social movement constitutionalism led the anti-slavery forces that shaped the clause, and indeed the entire amendment, to converge upon the proposition that certain fundamental rights needed to be secured, not just against discrimination, but absolutely. And by lasering in on legal history, he neglects this popular movement, and he neglects the degree to which the meaning of privileges and immunities changed over the course of time to the point where in 1868 it meant something very different than it did in 1788. What it meant was legally unorthodox. And yet, if we're going to be public meaning originalists, we're not concerned with a bunch of jurists or a bunch of treatise writers. We're concerned with what a reasonable person, a speaker of the English language, informed about the context of constitutional communication would have gathered from those words, and what they would have gathered was something that Republicans stood by and insisted upon frequently in the teeth of orthodox constitutional law at the time. Okay, first though, my view. My book argues that the origins of the 14th Amendment lie in the work of a multiracial social movement, abolitionism, that was once despised, the members of which were attacked and driven out of nearly every state of the Union, North and South. As early as the 1830s, abolitionists had a vision of a constitution that protected the fundamental rights of every US citizen and guaranteed to all people, citizen or not, protection for certain basic liberties. This abolitionist constitution guaranteed that every US citizen could travel to any state in the Union without fear of being deprived of their fundamental rights or treated differently than any other citizen. Now, for many years, few believed in the abolitionist constitution. But when the Republican Party emerged to challenge what was called the slave power, essentially the grip on all three branches of the federal government of a pro-slavery coalition that had dominated since the founding, the abolitionist constitution went mainstream. Leading Republicans like John Bingham, Jacob Howard, Charles Sumner, Thaddeus Stevens, names that should be as well known as those of Madison, Hamilton, and Jefferson, swore by it, and in the wake of the Civil War sought to realize it on the ground. The 14th Amendment, ratified in 1868, was an expression of this popular constitutionalism. It was also not supposed to be necessary. After the 13th Amendment announced a rule prohibiting slavery in 1863, Republicans hoped that no other constitutional changes would be necessary to enable formerly enslaved people to become citizens and to protect the fundamental rights and equality of all citizens. But the 13th Amendment's prohibition on slavery had an exception, except as punishment for a crime. And a number of the states tried to reproduce slavery through discriminatory criminal laws, known as the Black Codes, and the leasing out to private employers of Black people who were convicted of crimes and then worked to death. Thanks to this convict leasing, as well as other kinds of public and private violence in the former Confederate states against Black people and their white allies, it became apparent that more federal intervention to secure liberty and equality was needed. The 14th Amendment was framed and ratified to leave no doubt about the federal government's constitutional authority to intervene in this way. The need to expressly empower the federal government to act on constitutional convictions that most abolitionists had always held, but lacked the power to achieve until after the Civil War, had become so pressing that even the more conservative Republicans could appreciate it. This Republican understanding of citizenship included not only rights expressly listed in the text of the Constitution and the Bill of Rights, it included other rights that had developed over time and been embraced by most states. Some of these are listed in the Civil Rights Act of 1866, which the 14th Amendment was designed to place beyond constitutional doubt, but there are others as well that go beyond the right to make contracts, to sue and be sued, to convey and hold real and personal property, and to be subject to the same punishment as white citizens for the same crimes. These rights of citizenship came to include rights of equal access to public institutions like schools, rights to have one's criminal case tried before a jury that hasn't been purged of people of color, and eventually rights to vote, rights that have proven their importance to citizenship and became tightly associated with it, were privileges and immunities of citizenship. Now, for more than a generation after the Civil War, the Supreme Court denied those rights, said that they didn't exist, not as a constitutional matter. The court disabled Congress from legislating on behalf of freed people and their allies, striking down anti-Ku Klux Klan acts and federal laws prohibiting private discrimination. The court said that the 14th Amendment applies only to state action, and that state action doctrine is still with us today. Even when it comes to congressional efforts to protect people against what is unquestionably state action, the Supreme Court stands ready to stand in the way. The Republicans who drafted the 14th Amendment regarded Congress, not the judiciary, as the institution that would take the lead in protecting civil rights in the states. That's why Section 5 of the 14th Amendment provides specifically for congressional enforcement of civil rights. And it was written to give Congress a great deal of space to develop protective measures when states either failed to protect or outright attacked civil rights. Instead, the Supreme Court, to this day, micromanages Congress's work, treating any deviation from its own understanding of what constitutional rights are protected as presumptively illegitimate, even if that understanding is highly dubious as a matter of original meaning. Consider City of Bernie v. Flores. In Bernie, the court held unconstitutional the application of the Religious Freedom Restoration Act to the states. RFRA was considered congressional response to the Supreme Court's decision in Employment Division v. Smith, which held that the Free Exercise Clause didn't require burdens on religious liberty to be justified by a compelling interest and narrowly tailored. It just required that laws burdening religion be neutral and generally applicable. Justice Scalia made no attempt in his opinion for the court in Smith to justify this position as a matter of original meaning. But Bernick said that this didn't matter. The Supreme Court had spoken and Congress couldn't deviate from what it said. That's absurd. It's precisely the kind of thing that Republicans were worried about during Reconstruction, a court that took an unduly narrow view of civil rights and dictated that everyone else take the same view. The Constitution does not belong to the court. It belongs to the people of the United States, who can and should criticize it and contest its power with other constitutionally created institutions when it deviates from the Constitution. Now, I promised fireworks. Narrow though the court's current view of civil rights may be, Ilan's is narrower still. For him, citizenship is an empty vessel into which states can pour whatever they want or nothing at all. If a state wants to ban guns, it can ban guns. If it wants to ban public displays of faith, it can ban public displays of faith. If it wants to ban hate speech or misinformation, it can ban those things. Ilan just thinks states won't do that. He wants 50 flowers to bloom. If you don't like Employment Division v. Smith for free exercise, wait till you see it applied to every right you care about. That right can be taken away as long as everyone's equally unable to exercise it. And Ilan says that's the equality promised by the 14th Amendment. Ilan isn't Stephen Douglas. But like Douglas, I think he has an understanding of democracy that's belied by the facts on the ground. People are demonstrably willing to accept draconian restrictions on everyone's rights if it means that they can preserve certain status hierarchies that exist outside the law. Perhaps the most vivid illustration of this in recent historical memory is Southern States' response to Brown v. Board of Education and its follow-on cases. The Supreme Court requires desegregated public schools. Okay, we'll shut down schools. Desegregated public schools, pools, we'll shut down swimming pools. Does Ilan really think that states where majorities think that exceptions to generally applicable laws for religious people border on the establishment of a religion will hesitate to burden everyone's religious liberty, a liberty that they may not value all that much anyway? I think he does, which is the problem. Having said all that, I do think Ilan's view is a plausible account of original meaning, though not a probable one. And in a pinch between alternative accounts of original meaning, I think it's fair to ask, which gives us an account of civil rights that's more Lincolnian? Mine does.
I think I should have gone first, maybe. Thank you so much for having me here. I recognize a few of you. I've presented my book to the Indianapolis chapter before, and Covington, I think, and I like to say the book has at least 3 virtues. It's short, it's only 140 pages, it's cheap, it's only $20, and it has a really incredible cover. Now, I happen to think it has the 4th virtue of being correct. But this is more a matter of contestation, which I hope to convince you of in my few minutes here today. So let me say a word about the overall methodology of the book, because the methodology Evan already hinted at is really what's the innovation here. So basically why all the other books on the 14th Amendment are wrong. My claim is that the central rights-bearing provisions of the 14th Amendment, due process of law, the protection of laws, the privileges and immunities of citizenship, are written in the language of the law. These are legal terms of art that have long antebellum histories that we can discern and ascertain from treatises, court cases, famous constitutional battles, the Petition of Right of 1628, Magna Carta, and so on, and that we can establish these meanings with relative certainty without resort to the thousands of pages of Congressional Globe in the 39th Congress where you can find stray statements going any which way that can appear a bit confusing. So I want to be very clear, though. I'm not saying that the legal meaning is what governs us if it diverges from the original public meaning. My claim is actually that once we understand these are legal terms of art, the debates are clarified. It turns out that most of the debates in Congress and in the ratification period and in the public are consistent with these legal meanings. Okay. The biggest implication, if I'm right, about this methodology, is for the Privileges or Immunities Clause. I think it means the Privileges or Immunities Clause is not And the clause says, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. It's often thought that this is the provision that incorporates the Bill of Rights against the state. This is Professor Kurt Lash's view. Randy and Evans' view is that it not only incorporates, I use this word loosely, but it not only guarantees the fundamental rights in the Bill of Rights, but also other unenumerated rights, contract property, the stuff of Lochner, right, against New York. My claim is that the clause does neither. The clause is an anti-discrimination provision with respect to civil rights under state law. Okay? It is the Constitution's, the 14th Amendment's equality provision. If I'm right, what does this mean? I think it means California can ban handguns. I think it means Texas can abolish the exclusionary rule. I think it means California could say you can't operate a laundromat in a wood building without a license. What California can't do is say only white people can have guns. What California can't do is deny every Chinese applicant a license to operate the laundromat, but allow all white people who apply to operate the laundromat. Okay, so that's the stakes. Why am I right? Why am I correct about this? Well, as Evans says, it is basically beyond dispute that a key objective of the 14th Amendment was to constitutionalize the Civil Rights Act of 1866, which sought to abolish the black codes, the discriminatory black codes in the South that had arisen after abolition. So what was the Civil Rights Act? Let's quote it. The Civil Rights Act declares all persons born in the United States and not subject to any foreign power, and excluding Indians not taxed, but bracket that, okay? All persons born in the United States are hereby declared to be citizens of the United States, and such citizens, okay, of the United States, and such citizens of every race and color shall have the same right in every state and territory to make and enforce contracts, to sue, be parties, give evidence, to inherit, purchase, lease, sell, convey, hold real and personal property as is enjoyed by white citizens. Know what the Civil Rights Act does and doesn't do. It doesn't define any of these civil rights. It doesn't guarantee contract and property rights. It simply says whatever contract and property and gun rights and search and seizure rights the state provides its white citizens, it must also provide its black citizens. Okay? It is a non-discrimination provision. Now, there's no question that it was dubious whether Congress had the power to enact this, and so they needed a new amendment granting Congress the power to create the Civil Rights Act and to enshrine it in the Constitution itself, right? Because simply granting Congress power isn't enough. Because what happens when the Democrats take over, which they did in 1875, what's to stop them from repealing the Civil Rights Act and the Reconstruction legislation? So you need to embed the requirements of the Civil Rights Bill in the eternal firmament of the Constitution. Okay, in the words of future President, then Representative James Garfield. Okay, the question is, which clause of Section 1 constitutionalizes the Civil Rights Act? Okay? If the clause is written in legal language, which it is, then due process and equal protection don't do the job. Why? What's due process? I won't get into it. There's in the book. Evan disagrees with this. It's procedural. I go through a lot of the evidence. It's a short book, but I go through, let's say, the highlights, the key evidence that's cited. Due process of law simply means whatever rights you have, the government won't take them away without established law. Okay, there must be some law that you violate. That law must be established in advance. We will adjudicate your violation of that law according to established procedures. Maybe some fundamental procedures that no legislature can take away, but at a minimum, procedures known to the law. Okay, no substantive due process. What is the protection of the laws? Okay, protection of the laws is the flip side of due process of law. Protection of the laws was the legal protection the government had to give you against private interference with your private rights. It's not just the government that can interfere with your rights. It's your neighbors. It's the Ku Klux Klan. Okay? They can interfere with your enjoyment and exercise of your rights. The protection of laws was, number one, the physical protection the government had to give you against violence, private violence, from other citizens and other subjects. And two, judicial remedies. What happens when someone commits a tort against you, a battery, a trespass, they convert your property? They're interfering with your rights, with your life, liberty, and property rights. You have to have a remedy for recovering against them. Okay, don't believe me? Take it from William Blackstone. Blackstone said in his commentaries on the laws of England that the remedial part of the law, okay, the remedial part of the law, that is the method of recovering and asserting rights when wrongfully withheld or invaded, is what we mean when we speak of the protection of the law. Chief Justice Marshall, by the way, Marbury v. Madison, the very essence of civil liberty certainly consists in the right of every individual to claim the protection of the laws whenever he receives an injury. Remedial rights, okay? So the equal protection of the laws clause doesn't get us the Civil Rights Act of 1866 because it doesn't require equal civil rights. It simply says whatever rights you have, however unequal they can be, however unequal women's rights are, right? However unequal African American rights are, only the government can take away your rights, only with due process, and we will provide you protection of law so you can enjoy and exercise whatever rights we've given you, whatever rights you've retained, right? Free of interference from the Ku Klux Klan, okay? If I'm right about this, and I am, okay, then the only clause that's left is the Privileges or Immunities Clause. Okay? Now, there are some reasons to think that the Privileges or Immunities Clause is, in fact, what does constitutionalize the Civil Rights Act. Okay? Why? First, note the parallel to the Civil Rights Act. The Civil Rights Act begins with the declaration of U.S. citizenship and then says, as a privilege of such U.S. citizenship, U.S. citizens are entitled to equality and civil rights under state law. The 14th Amendment begins with a declaration of citizenship, national and state. Right? And then says, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. Okay? It's parallel, not exact, but it's parallel. Under my reading, the Privileges or Immunities Clause is also parallel to the Privileges and Immunities Clause, the Comity Clause of Article 4, Section 2 of the original Constitution, which was an interstate non-discrimination provision. Right? It says the citizens of each state shall be entitled to all privileges and immunities of citizens in the several states. The idea was if a citizen of Massachusetts comes to Georgia, Georgia can't treat that citizen of Massachusetts as an alien, as a foreigner. Georgia had to give that citizen of Massachusetts the same privileges and immunities, whatever they were, that Georgia gave its own citizen. Again, it doesn't require any sort of rights. It simply says whatever rights you give your citizens, you must give citizens of other states coming into your state. Okay? It's an interstate non-discrimination provision. If I'm right about the privileges or immunities, it does for intrastate non-discrimination what the Privileges and Immunities Clause did for interstate discrimination. Okay, let's look at the language. The language works too, okay? Yes, it says privileges or immunities of citizens of the United States. Kurt Lash would say, well, this is a reference to federal constitutional rights. But again, look at how the Civil Rights Act uses the concept. In the campaign trail, Schuyler Colfax, Speaker of the House, and others were asked, what are the privileges and immunities of U.S. citizens? And they said, we defined them in the Civil Rights Bill. The right to make contracts, the right to acquire and possess property. Those are privileges and immunities of citizens of the United States. What about John Bingham? John Bingham, the principal author of Section 1, defined the comity rights of Article 4, Section 2 that I just mentioned, contract rights, property rights, the state civil rights that a state gave its own citizens that it had to extend to other citizens when they traveled. He defined those to be the privileges of United States citizenship. They had this ellipses reading where they said that the clause guarantees that the citizens of each state, being ipso facto citizens of the United States, shall be entitled to all privileges and immunities of citizens of the United States in the several states. They defined these privileges as privileges of U.S. citizens. So public meaning, abolitionist meaning, actually tracks this legal terminology that I suggest. Okay. Does that mean you can't get incorporation? Well, it's awkward. It's awkward because then the word abridge would have to be an equality, do equality work with respect to some rights, but it would do fundamental rights work with respect to certain rights, and that's certainly weird. Now, you could think that the word abridge requires both equality and a fundamental minimum with respect to all rights, all privileges and immunities, including contract and property, and if that's true, I think you think Lochner is right, okay? Now, you certainly can think Lochner is right. It is a coherent position. If that is a coherent position, the question is what is the evidence? And the evidence is in favor of equality only. Of the 13 representatives to speak about the final language in the House of Representatives, 12 of the 13 said Civil Rights Act, Civil Rights Act, Civil Rights Act, Civil Rights Act, Civil Rights Act. 12 of the 13. Only Bingham then said something kind of incoherent. Kurt Lash doesn't think it's incoherent. We'll hear from him later. He will get the final word, alas, since he comes later. But it was all Civil Rights Act, Civil Rights Act, okay? Evans accused me of somehow being anti-fundamental rights, okay? The problem is, there was no doubt in their minds that all free governments had to secure natural rights. All free governments had to, and they believed that all the state governments did, at least with respect to their white citizens. Well, that's a bit more complicated. They thought slavery corrupted this idea of securing natural rights, but once slavery was abolished, liberty would be restored inherently. Okay? You don't need incorporation. Why? Because all of the governments, all of the state constitutions had a free speech and press clause. Why do you need incorporation if they protect all the same rights? The problem was the discrimination in the provision of these rights. That was the problem they were tackling, and all the evidence is consistent with that. Until you get to Bingham in March 1871. Then he changes his tune. But he said the exact opposite on June 30th, 1871, 6 weeks earlier, so we can sort of forget about Bingham in 1871, if you ask me. Let me say one last thing about implications, then I'll stop. What does this mean? What does this mean? God forbid that Texas can abolish the exclusionary rule. God forbid that California can experiment with handguns and corporate speech. Would that be so terrible? Would that be such a terrible world? Now, Evan says, oh, they can suppress speech. Well, I will say that viewpoint discrimination, which is the core of the First Amendment, well, I think that's sort of incorporated. It's baked into privileges or immunities, right? If privileges or immunities is anti-discrimination, well, viewpoint discrimination is the core of the First Amendment. That, I think, is sort of inherently through the privileges or immunities clause. If you let citizens speak on certain topics, that means you have to let other citizens speak on topics of their choosing. That's what free speech is, right? It's not just government-approved topics. But does this mean that all free governments, all states must have the same answer as to whether flag burning should be prohibited? Or whether you can have a tort suit for protesting at a dead soldier's funerals, or whether you can make it a crime to view Animal Crush videos, or whether you can prohibit the advertising of violent video games to minor, whether you can regulate student speech, whether you can prohibit stolen valor. These are 6 things that the United States Supreme Court has said are within the meaning of the First Amendment, that it is incorporated against all 50 states. I think under my view, the states would be able to experiment. Is that so anti-Lincolnian? I don't know. Thank you.
Professor Bernick, do you want to offer any rebuttal?
Sure, everything that he said was wrong. No. So let me just focus on 2 points. One is the methodological, actually they're both kind of methodological points. The thing that I keep telling Ilan is that he can have legal meaning, or he can have an anti-discrimination, privileges or immunities clause, but he can't have both. The orthodox legal meaning of the privileges and immunities clause, circa the time that the 14th Amendment was ratified, was that, as he just put it, it was a comedy clause. It protected people against parochial discrimination. You go into another state, you are discriminated against in the respects of how your rights are regulated or whether they are valued at all. That violates the Privileges and Immunities Clause. That's the legal meaning of the Privileges and Immunities Clause in 1868. But Ilan, because he recognizes that there's just absolutely overwhelming evidence that Republicans, as expressed in their party platform, viewed the Privileges and Immunities Clause as protecting people even against persecution by their own states, needs to kind of work the legal meaning of the Privileges and Immunities Clause into the Privileges or Immunities Clause as an anti-discrimination principle. The problem is that when you do that, you acknowledge that legal meaning departs from public meaning, and he can't have the neatness that he so clearly desires. The second point is that let me suggest that the reason that Ilan doesn't spend a ton of time discussing the legislative history of the 14th Amendment, which, by the way, was publicly available and the statements were repeated and circulated in major newspapers, is because it overwhelmingly refutes the argument that all that was going on here was an anti-discrimination principle. As Professor Kurt Lash points out, it is crystal clear that enumerated rights were seen as privileges or immunities of citizenship, and there were widespread complaints that states were not honoring those rights. We also have a speech by Jacob Howard, Senator Jacob Howard, introducing what would become the 14th Amendment to the Senate, specifically identifying the privileges or immunities of citizenship with 2 categories of rights, arguably one meta-category, but let's just go with the 2 categories. First, common law rights that were widely accepted and entrenched and associated with a decision by Justice Bushrod Washington when he was riding circuit in a case called Corfield v. Corio, including, yes, rights to contracts. The second is rights enumerated in the text of the Constitution. Howard is crystal clear about this. This was not an offhanded, incoherent statement. Bingham can be hard to parse, but Howard is crystal clear about these rights. This speech was covered in major newspapers. The substance of it was repeated on the campaign trail. Yes, it's messy. Yes, it's not clean. But that's the history that we have. And let me suggest that by focusing in on trying to capture a very tractable anti-discrimination principle that we can derive from a set of select legal sources, Ilan is neglecting some of the most important history that we have.
Can I maybe amplify that point? And I will do
You may
it.
not.
You're obviously not a litigant. I will do a poor job of articulating Professor Lash's position. He will do that later on. But I think he emphasizes Professor Wurman, your attention on the Judiciary Committee's work on the Civil Rights Act and other things, and ignores the separate, maybe parallel work done by the Amendatory Committee that I think Senator Representative Bingham served on, and that their work was perhaps different than the work that the separate committee was doing, and that it's maybe an oversight to not focus on that history. And I think there's a quote from Professor Lash's article, but talks about John Bingham repeatedly declaring that his amendatory efforts were directed at enforcing, quote, the Bill of Rights. Everyone listening understood him as proposing an amendment that would incorporate, to use a modern term, the Bill of Rights against the states. So I think Professor Bernick was sort of making the same point. You can respond to that or anything else.
See, this is the virtue of my methodological choice to focus on legal history, because there are, stray statements that appear to go every which way that could support any which position. So here is what John Bingham said on January 30th, 1871, as the author, with his name on it, of a Judiciary Committee report. This is in the Woodhull report. The Victoria Woodhull was seeking the right to vote under the Privileges or Immunities Clause. The problem is the privileges and immunities of citizenship excluded political rights. It was civil rights, natural rights, but not political rights like voting and holding office. Here's what John Bingham said. John Bingham said, and the Privileges or Immunities Clause does not, in the opinion of the committee, refer to privileges and immunities of citizens of the United States other than those privileges and immunities embraced in the original text of the Constitution, Article 4, Section 2. The Comity Clause, these civil rights under state law. In 1869, Jacob Howard clarified, if you will, his view, and he said that the key objective, again, of the Privileges or Immunities Clause was to abolish the hostile legislation against the colored man in the South. That was the goal. He doesn't say anything about nationalizing rights. He says the goal was, again, the unequal legislation of the states. And then we have, again, 13 representatives to speak about it. 12 of them said Civil Rights Bill. Section 1, Principle of the Civil Rights Bill. Principle of the Civil Rights Bill. 4 senators spoke about it. 3 said Civil Rights Bill. And then Howard said, what are the privileges and immunities of U.S. citizens? Well, Corfield v. Corio, contract property, and then, of course, the rights and privileges in the first 8 amendments. Okay? Well, those were privileges and immunities of U.S. citizens in the sense that these are the types of rights that all the states, in fact, guaranteed in their own constitutions. Yes, we have, as U.S. citizens, privileges and immunities, First Amendment privileges and immunities, Second Amendment, Third, Fourth Amendment, but these are all guaranteed and secured under state law. It is not at all clear, okay, that what Jacob Howard was talking about was the federal, as the federal Bill of Rights is understood by the federal courts, that is the version that is now imposed against the states. That is not at all compelled by his text. I'll just say one other piece, okay? John Bingham, in 1871, said, this is 6 weeks after the report I just read, said, I intended to make the first 8 amendments applicable against the states. He did say that in March of 1871. That is the first unequivocal statement about that. And you know what happened the next day? It was on a related point. James Garfield, again, future president, told Bingham, my colleague can make, but he cannot unmake history. I read through the Congressional Globe. The concern of all the representatives was the unequal legislation of the states. So it's like, yes, Bingham said something in 1871. Yes, Howard has this statement that can be interpreted as pro-incorporationists when he introduced it in 1866. But the overwhelming legislative history is actually against that view. It's actually against that view. I didn't mention the Bingham enforced the Bill of Rights thing, but I do have a response to that too.
I can say that Bingham contradicted himself 3 years after the 14th Amendment was ratified in a contempt to rely upon the publicly available statements prior to the ratification of the 14th Amendment as evidence of original meaning.
Okay, I'll let that one stand.
I'm going to ask one other question, and then we'd love to get questions from the audience. This question sort of relates to what you're talking about, but goes to maybe just a sort of higher level issue. So as a judge, as advocates, we really appreciate the great scholarship that the two of you have provided, Professor Lash and others, because we don't typically have the time in the course of an opinion or writing a brief to sort of dig into the history this way and to form opinions the way you can in your articles that you spend a couple years on, they get peer reviewed. But as a general matter, are there tips that you have for those of us who are not in the academy at discerning between different types of legal history, I suppose? I mean, what's good legal history and what's less reliable legal history, whether it's the framers, whether it's legislative history, whether it's talks. You could debate it in the context of the specific issue we're talking about, but do either of you have just sort of general tips for those of us who are in a sort of more expedited fashion trying to pick between different scholarship or different historical recounts?
Go with the short book. That is the best methodology that I've come up with.
It's oftentimes true that a short brief is more effective than a long one, so I will echo that. But
So one of the things that I'm trying to do is make it easier by just actually presenting the evidence and synthesizing it so that you do not need to rebuild the wheel each time. I don't think there's any substitute for digging through the newspaper records, for spending a lot of time in the legislative history, the pre-enactment legislative history, focusing on statements at the campaign trail, really immersing yourself in this, which isn't to say that judges need to do it, because we'll do it. And of course, the enlarged edition of his book is going to be slightly more substantial. So perhaps by that time, it'll be a comparable amount of work to make our way through both of our books.
I will say that Justice Thomas cited Evan, me, and Kurt Lash yesterday, and all three of us have different views, due process of the privileges or immunities clause. So what does that mean? I think you just have to buy all of our books and decide for yourself who's right.
But I do want to add, though, that this can present the appearance of a lot more disagreement than there actually is between us. We focus on the disagreements because we think that they matter, but it's telling that in a debate with Ilan, I am invoking Kurt Lash's work because I disagree with him on a bunch of stuff. But between us, I think that we present a picture of the 14th Amendment that is relatively coherent. It's not just complete chaos with people saying whatever. There are differences between us, but there's a commonality of method. There are certainly wide areas of law that we would agree about and would say either is entirely right or is entirely wrong or is based on the wrong clause. So it's not chaos, it's just complicated. But, that's law.
this would not be the first Federalist Society program where you found a very narrow area of disagreement and spent an hour and a half discussing it. So I think we're in good company there. Are there questions from the audience? Here's a hand.
Anthony?
Yeah, first of all, thank you, Ilan, for raising that concurrence by Justice Thomas the other day. I suggestion to Federalist Society that at some point you have a conference with everyone cited in that concurrence, and you call it something like a murderer's row of originalists, because it was all the great names were in there. John Hart Eli might be a little hard to get to that conference, but otherwise. So, Evan, question for you about privileges or immunities that I think some people might be wondering about. I read your and Professor Barnett's book. I read a good chunk of it when it came out, then I lost it. Then my wife found it in the back of our van, so I was able to finish it, which was fortunate recently. So I think you've sold me that privileges and immunities in Article 4 changed. And what they believed in 1866, 1868 is not the same thing that they believed in 1788. And that's how things work sometimes. But it seems a lot of that change happened pretty fast, pretty late in the process. So even in the 1850s, people weren't quite there, or Republicans, which didn't even exist before the 1850s, weren't quite there in how they viewed Article 4. But that there's this acceleration, and by the time, because of the social movements you talk about, a fair chunk of the American people read it that way in 1866. But it seems like it happens pretty fast.
This sometimes happens with our very thoughtful questions. Can you just get? We only have 15 minutes.
I'm sorry for elaborating. All right, is that a problem methodologically that the original meaning changes so fast that we graft one onto the other instead of something that was known for a long time, which is I think more Ilan's method because he's looking at the legal meaning.
I don't think it's a problem because I think that we can point to the historical reasons for it, namely the intensification of the persecution of Republicans who wanted to campaign in the South and found that they couldn't, and also an increasing, thanks to the apparatus of the Fugitive Slave Act, kidnapping of free black people, which in turn precipitated an intensification of the idea of fundamental rights that would be protected absolutely everywhere. Conversely, even on the parts of Southern Democrats, the idea that the Privileges and Immunities Clause of Article 4 was a fundamental rights provision that included the fundamental right to travel everywhere with your enslaved person also took roots at roughly the same time. So you see a convergence upon the idea that there need to be certain fundamental rights protected everywhere. We just disagree fundamentally about what they are taking place within that short time. And sometimes legal change is very nonlinear in that way, and that doesn't bother me so much as it reflects my best understanding of what we would expect given the nature of the history.
Question? Sure, here.
I came across a couple of methodological questions. I think the first being to Professor Wurman. It appears that to kind of combine both arguments here, that the original public meaning might have been warped slightly by persons like Howard and Bingham when they were on, say, the campaign trail. But for Professor Wurman, wasn't it your last book that was all about original public meaning and the function thereof? And so does that not lend itself a little bit to Professor Bernick's position? On the flip side, Professor Bernick, if these rights developed over time, was your quote, is that verging on the edge of living constitutionalism?
No. Original public meaning requires us to follow what the criteria for inclusion in the set of privileges or immunities of U.S. citizens is. It doesn't include the possibility that those criteria might be something along the lines of those rights that are broadly accepted in the states and associated with citizenship. And if you have that, you have, as a matter of original public meaning, an expanding set of fundamental rights. Now, oh my God, that means that there are going to be new rights. Well, yes, there are. I'm confident that that's where the evidence leads. And also, I would add that my method of identifying new fundamental rights is a lot more constraining than the current framework for identifying substantive due process rights, which is this gauzy, deeply rooted in the nation's history and tradition stuff. We say 2/3 of the states for a generation. You know, it's clean, it's clear, and it's demanding. It's almost as demanding as the ratification of another constitutional amendment because we recognize that that's kind of what it's like. And we emphasize that judges do not have the ability to identify rights without identifying a consensus in the states over an extended period of time. They can't just say, we think that this right is fundamental because it's associated with citizenship now, regardless of what the states think about it.
Trying to hoist me by my own petard there, I see. So I will say that I think that if original public meaning diverges from legal meaning, I think we're bound by the original public meaning. Okay, and the question is how common is this? And by the way, so I kind of have Daniel Webster's view. There was this debate in the 1840s over whether Congress's power to enact a uniform bankruptcy law includes the power of debtor relief, which was insolvency in like British history, legal history. Bankruptcy and insolvency were different, and these high Federalists were like, oh, only creditor relief, not debtor relief. And Daniel Webster was like, whoa, 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 what matters is the authentic meaning attached to it by the people who ratified it, and bankruptcy in the popular mind has always been, both bankruptcy and insolvency. Fine. That's not my dilemma here. Because my claim is that once we look at the legal meaning, it turns out that 99%, if not 100% until March of 1871, of the public meaning actually aligns with and so that takes me to the other point you made, which is, did they muck it up on the campaign trail, which takes me to this. Bingham wanted to enforce the Bill of Rights against the states. He had a speech that says we need to enforce the Bill of Rights against the states. Let me put this in context. Okay, this speech was made in February of 1866, and then he repeated this argument a few weeks later in the debate over the Civil Rights Act. He said, we don't have power to enact the Civil Rights Act because we don't have power to enforce the Bill of Rights against the states. Whoa, that's weird. How do you get from equality and contract and property rights to the Bill of Rights? What is the connection there? The connection is that John Bingham, thought Article 4, Section 2 was within the Bill of Rights. He said, gentlemen, admit the force of those provisions of the Bill of Rights, that the citizens of each state shall be entitled to all privileges and immunities of citizens in the several states. He included Article 4 in his definition of the Bill of Rights. And he had, I admit, an unorthodox reading of the Comity Clause, where he thought it also extended the non-discrimination requirement to a state's own citizens. Okay? So how do we so when he says, I want to enforce the Bill of Rights against the states, what he wants to do is enforce his non-discrimination reading of Article 4, and the states will be required to treat all of their citizens equally. Okay? Now, he knew he was doing something unorthodox, because when he talked about comity, he said Article 4 requires a state to treat its own citizens equally. In a speech he made on this, he said equality in the right to know, and the right to live, and the right to learn. Right? That's what he sought. He said, why? Because the citizens of each state shall be entitled to all privileges and immunities of citizens of the United States and the several states. Which means if there's a citizen of the United States in your own state, you can't discriminate against them. And that's why he changed his initial draft, right? Which was Congress shall make all laws necessary and proper to enforce Article 4, Section 2, right? To saying citizens of the United States. He basically took his unorthodox reading and changed the words of the 14th Amendment so that it reflected his understanding. So I think that the original public meaning is perfectly consistent with the legal meaning. For Evan to be right, that the Comity Clause changed its meaning, the final language of the 14th Amendment would have to track the Comity Clause's language. And then he would have to say, but there was an unorthodox reading of the Comity Clause's language. But they changed the language. They didn't say citizens in the several states, they said citizens of the United States, because they knew that their reading was unorthodox, so they had to change the language. I think that's all consistent with my view. That's all a bit confusing. I've got a 120-page paper on all this, longer than the book.
Sounds like you need a third book. Those are good questions. Thank you.
Well, books should be short. Law review articles can be long.
Thank you. What, if any, impact does the 14th Amendment have on residents of the Capitol? What, if any, impact does the 14th Amendment have on residents of the Capitol or Congress's authority over the Capitol?
The Citizenship Clause of the 14th Amendment is self-executing. It proclaims that all persons born in the United States and subject to the jurisdiction thereof are citizens of the United States and the several states. That includes citizens of the District of Columbia. Therefore, even without the operation of the Privileges or Immunities Clause, the Due Process Clause, or the Equal Protection Clause, you cannot abridge the privileges or immunities of the citizens of the District of Columbia or in any federal territory.
It's a tricky question, right? It's hard because the premise of your question is Bowling v. Sharp wrong, right? And Bowling v. Sharp reverse incorporating equal protection from the Due Process Clause of the Fifth Amendment, right? Because the Privileges or Immunities Clause, equal protection, wherever you think the equality work, it applies to states, not the federal government. So does that mean the federal government can discriminate? And it's tricky, right? If it comes from anywhere, it has to come from the citizenship clause. I agree. And Gary Lawson has done work on this. Ryan Williams has done work on this. And I do think that they believe that citizenship in a republic implied equality, okay? Which is why, by the way, when states discriminated against free black citizens from other states under the Comity Clause, like they tried to exclude free black citizens of other states, they didn't say, well, you have the same rights that black citizens have in our state. They didn't say that. They denied they were citizens at all. Because they knew that if they were citizens, that would mean that the states would have to treat them equally. Chief Justice Taney, in his argument in Dred Scott for why blacks were not citizens, was not, he didn't, what was that? If they were citizens, what would be the consequences under the Comity Clause? It would mean a black man could go freely at night like a white man without a pass. It means that they could talk about whatever subjects white people talk about. They can carry guns. If white people can carry guns, right? They said they knew that if they were citizens within the meaning of the Constitution, then they were entitled to equality, which is why they denied they were citizens at all, instead of saying, oh, they get the same rights that black people get in our state, meaning nothing, right? But then that raises the question, as applied to the states, is the Privileges or Immunities Clause superfluous? If citizenship already requires equality, right? And the answer, which I take from Evan's co-author, Randy Barnett, is that, look, redundancy is good in airplanes, and it's okay in constitutions. I think that's right.
I just want to express a brief, hard disagreement with the proposition that recognizing the citizenship of black people would be sufficient to protect them against arbitrary discrimination. Women were citizens during this time period. I rest my case.
Yeah, and it's true. It's true. And when you look at the Missouri debates and what does it mean to be a citizen, they said age and sex, those are reasonable grounds to discriminate because they're morally relevant to the various rights that exist, rightly or wrongly today. Obviously, wrongly we think of especially as to sex today. But they said in the same breath, however, if blacks were citizen, clearly skin color would be an arbitrary basis. Now, eventually, over time, they started making the alternative argument, being like, well, we can still, just like we can discriminate against paupers and we can exclude paupers, we can exclude this dangerous population, right? But you can't exclude them if they're citizens. You can't. And so they still denied that they were citizens, even then.
You could discriminate against paupers if they were citizens.
I think they thought that that was a reasonable ground on which to discriminate because and by the way, to be clear, I don't think they thought that they could discriminate against their own paupers, okay? In the context of the Comity Clause, okay, which requires you to treat citizens of other states with equality, paupers were excluded. Why? Because paupers were the responsibility of the place of legal settlement, right? Why? Where you grew up, where you paid taxes, your community was responsible. And that was a reasonable basis to discriminate against citizens from other states. But even in the Missouri debates, they talk about pauperism. And someone said, I never understood that a pauper can be excluded as such, only that he can be removed if liable to become a public charge. Even that, I think, makes sense in the scheme of antebellum things. I'm not arguing with you that, obviously you can discriminate even once you make a declaration of citizenship, which is why we needed the Privileges or Immunities Clause, right? Redundancy is good. Hammer the point home. I just think that's more evidence in my favor. All the evidence is in my favor. That's okay.
Thank you so much. I guess this is for Professor Bernick, and it seems like the 2/3 of states plus 20 years formula is really well calibrated to preserve Warren Court precedents as sort of constitutionalized, and then slightly past the Warren Court, Roe v. Wade. And I was just wondering how your constitutional approach deals with those precedents that many people probably think conflict with the original public meaning as originally understood, but are rights that have been constitutionalized in 2/3 of states plus 20 years.
Well, they were constitutionalized as a consequence of the Supreme Court saying that they were constitutionally required, which I think gives it a different dynamic than would otherwise be recognized under our framework. So basically, if the Supreme Court says this is a constitutional right, and a bunch of states then say, yes, this is a constitutional right, the clock for the purposes of our analysis doesn't actually start. This needs to be an emergent consensus, not one that is led by the Supreme Court saying this is the right, even if it isn't recognized in most of the states. So those cases, those Warren Court cases, don't get locked in. If they're overruled on the grounds that they're inconsistent with original meaning, the clock starts again. And there's nothing that prevents the Supreme Court from, on the basis of original meaning, saying that those decisions were wrongly decided.
One last question? Sure.
Yeah, this is for both of you. We talk about the original public meaning, but at this time, who is the public in two ways? First, do we include the newly freed people? And second, the 14th Amendment was sort of coerced on the southern states. Are they a part of the public, and does their interpretation matter? And was there one public who could have a meaning at this time?
By the way, we started 10 minutes late because my co-panelist showed up at the Lincoln Public Library, not the Presidential Library. So two points. I think we can go a few minutes over, right, Judge? But more importantly, don't believe anything that he says. You can't trust them. I'll take and I know Evan and I actually agree about this, that Black voices should count for this, and I think we disagree. Because, and it's also not crazy because at the end of the day, look, the freed people in the South did participate in the ratification conventions. They participated, under the Congressional Reconstruction laws. They were given the right to vote before the 15th Amendment. This is, by the way, the cover of the first vote. Okay, this is pre-15th Amendment. This is 14th Amendment. The first time the newly free people voted was under the Reconstruction laws. Okay, giving the newly freed people the right to vote in the South. They voted for delegates to constitutional conventions that would make new state legislatures that adopt, that eventually would ratify the 14th Amendment. They were also part of those. So they were part of the public, okay? And I do think Evan and I disagree a bit about them, but listen to what there were, throughout the antebellum period and a little after, there were so-called colored conventions all over the United States, okay, where free blacks got together and expressed their grievances and their views. And here's one in 1867 from Alabama. As there seems to be considerable difference of opinion concerning the legal rights of the colored man, it will not be amiss to say that we claim exactly the same rights, privileges, and immunities as are enjoyed by white men. We ask nothing more and will be content with nothing less. Color can no longer be pleaded for the purpose of curtailing privileges, and every public right, privilege, and immunity is available by every individual member of the public. That is the touchstone. So long as a park or a street is a public park, then the entire public has the right to use it. So long as a car or steamboat is a public conveyance, it must carry all who come to it and serve all alike. The law no longer knows white nor black, but simply men. Okay? Again, nothing about incorporation, nothing about radically altering the division of federal and state power. It's all about equality. Just like what John Bingham said in 1859. The interpolation of white and black into constitutional rights is what I oppose. So I think my view is very consistent with what the various colored conventions maintained. As for coercion, do you want to take that one?
Yeah.
I have some thoughts too, but.
When you fight a war for white supremacy and sever the Union into pieces, I don't care about whether you're coerced, and I don't think that as a matter of original meaning, it has any force whatsoever. The matter that we are focused on is what a reasonable person, which is, a constructed account of what most people who would have engaged with the Constitution in that text, competent in the English language, would have taken those words to mean. And it's possible that you would have had interpretive communities that disagreed about the basic concepts that were conveyed by the words, but I don't think that Ilan and I disagree that there's just not a lot of evidence of that. The closest thing to like an actual, something that would have actually caused an ambiguity actually involves voting rights. Because if you look at the records of the colored conventions, you find an insistence that voting rights were among the privileges and immunities of citizenship as Black people understood them. Of course, the 14th Amendment itself seems to contemplate in Section 2 that states could deny voting rights to Black people so long as they were prepared to pay in the form of reduced representation in Congress. And it was because of this apparent conflict between what most Black Americans understood privileges or immunities to entail, namely voting, and the text of the 14th Amendment, that Frederick Douglass actually fought against the ratification of the 14th Amendment because he didn't think that it guaranteed all the privileges or immunities of citizens. But that very understanding that even someone who held a distinctive view of the privileges or immunities of citizenship from what we would say is was the majority view, was capable of seeing that the 14th Amendment didn't encode his understanding of the privileges and immunities of citizens, that evinces a broad understanding of what that text meant, even if one disagreed with it.
Since we gave ourselves a couple of extra minutes, can I sort of offer one final observation? And Professor Wurman, you can let me know.
You may. No,
Thank you. You can let me know if this is right or not. But so my understanding of your theory is that citizens of the various states have the rights guaranteed to them by their state constitution, but not much else. And I was just thinking about how history would have played out quite differently had that been the case. So Chief Judge Sutton from my court has written 2 books now about the role of state constitutions and how important they are. Sort of make the point to remind people that yes, there's a federal constitution for which you can invoke in court, but you should also be thinking about the state constitution. But it's quite interesting to think that actually the history would have been that the state constitution would have been effectively all you would have had. And I know Justice Slaughter is here from the Indiana Supreme Court, so I'm thinking about how important that job. It's a very important job. How the increased importance that job would take on, and relatively lesser importance, I guess, the job a federal judge would take on. So I don't want to offer an opinion on this, except to say, am I right about your sense of how history should have played out, or if history had changed course, how it should play out going forward?
It does, Your Honor, and with no offense intended to you, I think that is a virtue.
Well,
I think that's correct.
great. Well, please join me in thanking our panelists.